Our next case is People versus Tyson. Good morning. This is a 15-minute mini oral argument on the application, and it's my understanding that you'll be sharing the first 15 minutes, and Ms. Lashinsky will have 5 additional minutes.
That's correct, Your Honor. I understand.
And if you're going to reserve time, we just ask that you track that and then divide your time however you're choosing to do so, but also keep track of that.
Thank you, Your Honor. I understand that. Good morning, Justice Clement. Good morning, Justices of the Court. Michael Ferrone on behalf of Ms. Tyson. Thank you for granting oral argument today. In his closing at this trial, the prosecution stated, quote, "The reason Ms. Tyson did it may very well be because of her delusions. It could be a result of her mental illness." By the way, I would waive any question-free period because I will be up here a shorter period of time. Diminished capacity, unlike legal insanity, does not excuse or justify a crime. Rather, it involves the introduction of evidence of a mental disorder to negate the mens rea of a specific intent crime. If accepted by the jury, the accused is not acquitted or likely convicted on a lesser offense. Would it not be just to have allowed Ms. Tyson to argue, "I did not commit the crime charged because I did not possess the requisite mens rea due to mental abnormalities no one disputed that I suffer under"? After all, making the prosecution prove their case, including the mens rea element, is a basic principle of American criminal law. When this honorable court eliminated the diminished capacity defense, the issue of its continued existence had not been preserved. Wasn't raised before the Court of Appeals. It was raised in a responsive brief in this court. The result, Carpenter, runs counter to our long civilizational history of recognizing a connection between mental states and moral culpability. And as Justice Kennedy noted in Clark v. Arizona, a substantial majority of the states permit the introduction of mental illness to negate the mens rea. Actually, he stated a substantial majority of the states, he apparently he surveyed the states and found the majority of the states have the diminished capacity defense or its equivalent. I didn't know until I briefed this case that actually the Sixth Circuit case law allows the diminished capacity defense even on some general intent crimes. So, when we read Carpenter, we may have the impression that it's kind of unbelievable that the defense even existed in 2001, but the majority of the states view that differently. Overturning Carpenter will produce no upheaval. Subsequent decisions have only limited Carpenter's reach, not least People v. Yost, and the force of stare decisis is at its nadir in cases concerning criminal rules that implicate constitutional protections. The Carpenter dissent was rightly troubled that the majority had, their phrase, deduced from, close quote, the insanity and guilty but mentally ill statutes, an intent to abrogate the common law despite no statutory language, nothing in those two statutes indicating an intent by the legislature to abrogate the diminished capacity defense.
Counsel, can you, assuming, let's say that we agree with you on all those points, can you address the preservation problem? How are we able, if we wanted to, even to reach these issues, given the preservation problem in this case?
The position I've taken is that the preservation doctrine, the razor wave rule, doesn't apply because the reason for the rule doesn't apply. The reason for the rule is that we want to solve problems as early as possible. We want objections to be made in the trial court so that the trial court can remedy, if there is a problem, remedy it and thereby avoid a mistrial. That's the very reason for the preservation doctrine that's been stated many times by this court. In this case, that couldn't happen. A trial counsel could have objected, but number one, they're never going to. Trial counsel, that's just not what trial counsel does. They have enough sort of issues to deal with, and I don't believe most trial attorneys are thinking about, well, I'm going to bring this objection because possibly the Michigan Supreme Court is going to grant me relief years down the road. They don't think that way.
But isn't the preservation rule also to make sure that the issue is fully developed in the lower courts so that when it comes to us, we have a full and complete record? You're proposing a rule where you can ignore it, and then throw it on the Supreme Court when everything else has lost?
Respectfully, no, because whatever the rule is, people can raise issues on appeal. This issue was raised before the Court of Appeals, and it was denied in, I think, 3 sentences. So, no, if what I proposed would only, let's say, would only take up the court's time if the court was interested in that precedent.
So are you just based on just, it's a legal issue, the court can take this, or is it that it would have been futile at the lower court to
Both.
object? Because we have this strange tension where if you bring up, if you actually argue meaningfully diminished capacity at the lower court, that could be found to be ineffective assistance of trial counsel. So it's a strange tension where you're supposed to preserve something that also could be considered ineffective. So it does seem in tension. So but we know Michigan has not recognized a futility exception to preservation.
Well, fair enough. The doctrine in Michigan is that when appellate courts review issues of statutory interpretation, it's done de novo. And so that's not exactly on point with preservation rule. I understand that. However, it's not so far removed from where we are. We're looking at these statutes and asking for a de novo review. But to answer the original question, both. It would have been a futile objection. It would have necessarily been denied. And I forgot the second part of your question.
Whether it was ineffective assistance of counsel, we know that there.
Yeah, exactly. It can't be ineffective assistance to make a futile objection. So I can't argue ineffective assistance. It doesn't actually fit under the plain error doctrine either. I think the prosecution's conceded, or I believe the Attorney General's conceded that. It doesn't fit because we're asking for a change of law. There's clearly not plain error when the law clearly prevented the defense from being presented. It doesn't fit either of those two doctrines. And so where are we?
What about the notion that you have already acknowledged that all of this evidence already came in this case? So how would you show prejudice?
Well, thank you. There's 2 parts to that. First, return to Justice Zara's question. The evidence is there. The record is there. What's missing is not the evidence of diminished capacity. I think what's missing is opinion. In particular, the state's expert wasn't asked for her opinion on whether defendant suffered a diminished capacity because it wasn't in front of the court. I think your question's a bit different, Justice Viviano, which is prejudice. The prosecution's argument is that there's no prejudice here because the trial judge had found that Ms. Tyson had formed an intent to kill. Therefore, he sort of implicitly rejected a diminished capacity defense. I would submit that's not true. If we look at fortunately it's a bench trial, we have the findings of the trial court. The trial judge actually spent little time on the phrase intent to kill. He did 3 things. He broke the arguments up into 3 parts. 1, did the crime occur? That was fairly easily resolved. Clearly the crime occurred. Clearly Ms. Tyson was the actor in the crime. But then there was one part of that which was a little more nuanced, and that was premeditation. And he discussed premeditation on that issue, whether, and he said that regarding the homicide of Ms. Johnson, he found that to be a second-degree murder. Then he said that there was a small, brief passage of time, and based on that, he found premeditation as to the homicide of Ms. Work. It was only then that he turned to whether Ms. Tyson was mentally ill, that he spent little time on that. Everyone agreed she was mentally ill. And it was only after that that he turned to an analysis of what he considered, I think correctly, the heart of the case, whether she was legally insane. And so every finding made from that point forward was through the prism of the legal insanity defense. Diminished capacity wasn't in front of him. And if we look at these findings, the first finding was that Ms. Tyson described herself as typically a good person. Well, that's the McNaughton rule, essentially, was what the judge was addressing. She knew right from wrong. That's the insanity defense. It doesn't tell us anything about what the trial judge would have done with diminished capacity. Next, Ms. Benedict found that Ms. Tyson, failed to convey her thoughts.
You understand you're eating into other counsel's time?
I apologize. And if it's
I'm letting you know.
No, if it's agreeable, unless the court has any other questions, thank you for interrupting me. I'll sit down. Thank you.
You have 6 minutes on the clock, and that includes any time that you'd want to reserve for rebuttal.
I will do my best to reserve time for Mr. Ferrone's rebuttal. Adrienne Young for Amicus CDAM from Sato. I'll keep track of my time and, like I said, reserve what I can for Mr. Ferrone's rebuttal. People v. Carpenter was wrongly decided. This court did not adhere to its own principles of statutory interpretation, including the importance of plain language and the intention of the enacting legislature. The relevant statutes here did not mention, much less enact, or exclude diminished capacity as a partial defense. Under constitutional avoidance, this alone should put this issue to rest. However, I'm also prepared to argue that the outcome in Carpenter is wrong on state and federal constitutional grounds.
Counsel, given we have limited time, I want to jump forward to the preservation issue. Just wondering what your thoughts are on that in this case. Do we have to create a futility exception? Do we just get there on the law alone? What do we do?
Well, candidly, that's not within the scope of the amicus brief, but my thoughts on that are that this would be forfeiture and not waiver, given all the points Mr. Ferrone has just made about counsel did everything they could up until the point that the law prohibits anything further. So as Mr. Ferrone said, there was extensive testimony from experts and from multiple experts. This record is rife with information about the fact that Ms. Tyson suffered a mental illness. And so counsel did everything they could short of confronting a law that prohibited more. And so that rings in terms of waiver and not forfeiture, or in terms of forfeiture and not waiver to me. So it would make sense in the future to have futility, because I don't think that every trial counsel is going to do this, nor do I think that they have to, because of the way Carpenter is written to wholeheartedly exclude, without exception, a diminished capacity defense. So had this court been presented with a record that wasn't so complete with evidence of mental illness, I still believe that this court should consider the issue. And so to the end that that's necessary and the court deems a futility exception necessary for that, I think one should be carved out. But here that's not necessary because it's forfeited and not waived. So I'm going to reserve the rest of the time for Mr. Ferrone's rebuttal, but I just want to leave the court with this language from Clark v. Arizona. Clark v. Arizona said, "The right to introduce relevant evidence can be curtailed if there is a good reason to do that. There is no good reason offered by this court to curtail the diminished capacity defense, and there is no statutory support to do so." Thank you.
Thank you.
Good morning. May it please the court, I apologize for my voice. My name is Amy Lashinsky, and I represent AMICI, the American Psychological Association, the Michigan Psychological Association, and the National Association of Social Workers, including their Michigan chapter. In Carpenter, this court created a very specific rule of evidence that singled out mental illness evidence for exclusion, even where very similar evidence would be admitted. For example, consider two people who, after experiencing the sensation of being stabbed, shoved the presumed stabber off of a cliff. One person would be able to admit evidence that he felt a sensation of being stabbed because it was the result of nerve pain or sciatica or something like that. But the other person, because his sensation of being stabbed was a hallucination, he would not be able to admit that evidence. This categorical bar on scientific evidence of mental illness to negate specific intent ignores an empirical reality well established in the relevant scientific community, that symptoms of mental illness can and do affect the ability to think and plan in ways that may be probative of specific intent, even in individuals who would not be considered legally insane. In considering whether or not to overrule Carpenter, this court should consider, consistent with its People v. Parks decision, consider the scientific evidence presented in our brief. I welcome the court's questions. Hearing none, take the facts of People v. Castile, which is a Court of Appeals decision that we cited on page 4 of our brief. In that case, the defendant was beset by powerful delusions that he was being, it was like a vast conspiracy that he was being pursued. And he was driving on the highway and he was shooting at the people he thought were his pursuers. He was ultimately charged with terrorism, and he was unable to negate the specific intent element of an intent to cause fear because his story was that he was shooting his pursuers. It was all tied up with his delusions. Delusions like those allegedly involved in Castile and hallucinations, their close cousin, can be devastating, and they affect people outside of the actual hallucinations. So one study, the Mintz and Alpert study that we cite in our brief, found that people with hallucinations are worse at assessing the accuracy of their perceptions, even when they're not hallucinating. Another study, it's discussed in Rinaldi, found that schizophrenic people are worse than healthy people at recognizing, for instance, when a visual image of a joystick does not align with the physical joystick they are manipulating but cannot see. Schizophrenic people are also more likely to recall things that did not happen. That's the Seabury study. Then that's when they're not hallucinating. Actual hallucinations, of course, are many times more debilitating and make it even more difficult for people to distinguish between reality and the hallucination, meaning the actions of the mentally ill may not align with the specific intent required to be convicted of certain crimes. Excluding that evidence contravenes the legislature's intent in defining specific intent crimes. Or take the case of a defendant who breaks into a home on a cold night and engages in bizarre or menacing behavior. Charged with first-degree home invasion, he cannot rebut the specific intent element to commit a felony by showing that he suffers from disorganization, a cluster of symptoms that includes bizarre behavior and unusual thoughts. Disorganization can seriously impair an individual's ability to monitor their own behavior, understand the intents of others, and work towards a goal. Individuals with disorganization struggle to track and recall sequences of events. For instance, in the Zala study, the participants were given a series of 5 picture cards and asked to put them in order. And the pictures depicted like brushing your teeth, going to the movies, things like that. And the participants were given them in random order and asked to arrange them in the correct order. Individuals with disorganized symptoms took longer to complete the task, had more errors, and were struggled to recognize the theme of the story. These findings and the findings of other studies like it indicate that disorganization is associated with an impaired ability to track and recall sequences of events, and which is, of course, an important aspect of planning. That evidence is therefore highly probative, and its exclusion under Carpenter contravenes legislative intent. Another example is impulsivity. One study discussed in Moeller found that incarcerated individuals with premeditated aggressions exhibited different patterns of brain activity than incarcerated individuals with impulsive aggression. So there are actual biological differences at play. Yet a defendant charged with premeditated murder would be unable to show that she was incapable of premeditating because her actions were moving faster than her thoughts, even though she would be able to introduce very similar evidence under involuntary intoxication, if, for instance, the difference had been caused by a medicine rather than her own, biochemical profile. Finally, consider a defendant who kills in what may seem like a deliberate, actually I see that my time has expired. If I could just.
Yep, you can finish your point.
Thank you. So in conclusion, the science firmly shows that mental illness evidence can be highly probative. Excluding that evidence contravenes legislative intent, and in deciding whether or not to overrule Carpenter, we ask this court to consider the relevant science.
Thank you very much.
Thank you.
May it please the court, Michael Tesner appearing on behalf of the people. I know the court has ordered us to address Carpenter, but this is not the right case. The court should deny the application or affirm, at the very least, affirm the defendant's conviction. The defendant did not preserve this issue, and it was not plain error for the trial court not to raise this issue on its own for the defendant. And even under plain error review, there was no prejudice to the defendant. It did not affect the outcome of the case. The defendant had psychological evaluation. There was full testimony from 3 experts. The trial court still found the defendant acted with specific intent, despite finding she was mentally ill and acknowledging her symptoms. This would not have changed even had the defendant argued that her mental illness diminished her capacity to form specific intent. How do we determine intent? Just as in any other case, by words and actions and deliberate decisions made by the defendant. In this case, the court found that despite her mental illness, the defendant engaged in goal-directed behavior. She chose her two victims. She chose not to assault other people that were present at the same time, and even told one who was fearful, "I'm not there for you." The defendant acted with specific intent to kill Tammy Johnson and to kill Lyric Work with premeditation and deliberation. So whatever else the court might decide, the court should affirm the conviction. To address Carpenter, in 2001, Carpenter held that the legislature meant to occupy the field in this area when it passed comprehensive legislation dealing with the defenses based on mental illness. The defendant must follow the procedures of the statute to pursue a defense based on mental illness or intellectual disability. The court specifically rejected the diminished capacity defense. And then 1 year later, the legislature passed an act, amended that area of the law to allow a diminished capacity defense for involuntary intoxication under 768.37. The legislature clearly was aware of the concept of diminished capacity, and yet they did not allow diminished capacity defense in any other context, and they still haven't, 21 years later. And the defendant and Amicus now ask this court to hold that Carpenter was wrongly decided, but the arguments center on policy reasons. The science has changed. I can't take issue with the American Psychological Association, but those are all considerations that have developed since Carpenter even, and especially since 1975 when the statute was passed. Society also has changed in appreciation and response to mental illness. The defense, in their various briefs, have talked about mental health courts and different ways that mental illness is viewed in society, but these considerations also are policy decisions that the legislature can consider if they deem it appropriate to amend the statute. Why must a defendant with mental illness follow the procedures of insanity defense statutes? Because the search for truth would be thwarted if the procedures of the statute are not followed. Outside of the statute, there's no notice requirement. The people have no ability to compel an independent psychological evaluation except what's in the statute. The defendant should not be free to shop around for an expert witness until one is found to support their claim, especially in this important area. And we wouldn't even be able to determine that they've done that because we don't have access to that discovery. We only get a witness list and a report, and then we, get our opportunity at that point.
When we're looking at preservation,
Yes.
should it matter to us that the factual record would have been no different had defense counsel attempted to raise the diminished capacity defense?
Well, yeah, I think it does make a difference. The evidence is there. The evidence is in the record. But the defendant didn't make the argument. The trial court wasn't presented with the argument. So if you're asking, do the rules, should preservation rules apply? I think they should. So number one, when an issue is not even involved in the case, it wasn't raised by the defense, they're not claiming ineffective assistance, and it wasn't a decision that the judge could have made. So there's nothing to review. There's no error to review.
How would that ever get reviewed then?
Well, it has been raised in the past. There are cases, in fact, I can't remember
So it's like
which.
the magic word, say the magic word. I mean, I get like the point that counsel made about the purpose of waiver and what Justice Zara said of getting a full development and having, a record developed. But when we have said in Carpenter that this is, a done deal, it's going nowhere, what development of a record are you going to get in the lower court that is, furthered by enforcing the preservation rules?
Well, the defendant, and we do this all the time in the lower court. We we make our argument, even though we know that we're going to lose. We want to preserve the record. We we're going to make a record to preserve our argument.
So the record here, like all the record evidence is in the record, right? All the evidence in support of it is in the record. What's lacking is
The argument is,
the argument.
there's no
that-
argument? I'm sorry.
Okay.
I don't mean
No,
to
I
interrupt.
mean, but so is that sort of form over substance?
Well, we're lacking the argument that this would, that this would apply and make a difference in this case.
Well,
I
but
mean,
could the trial court have found that? Could the Court of Appeals have found that? Could anybody other than us have found that?
The trial court could have ruled that if the diminished capacity defense existed, yes, it would apply here, but it doesn't. I see your point, though. So we are here and we are talking about it, but we don't have that opportunity to review the argument that would have been made by the trial attorney in the trial court, by both trial attorneys. Now, the fact that we do have the record does give us the ability to look at it and determine what the court actually did and what the court, with the knowledge of the entirety of the defendant's mental exams, the evaluations and opinions, the court still looked at her actions. And in fact, they talked about, the experts talked about how someone can operate even through their delusions, and they can still make decisions. And that's essentially what the court found here, because clearly the defendant was mentally ill. Clearly the defendant suffered from delusions. We didn't dispute that. But the defendant still committed 2 murders, and there was evidence outside of the, both from the defendant to the medical experts, but also from scene witnesses that indicate that she was in the office and the regional manager was outside the office and heard the conversation going on, saying, no one else has a key to your place. No, there's a key, it's in a lockbox. No one can get into that box. And then she heard, it's probably just dust.
But those are
And then
lay
there was a gunshot.
witnesses, right? I mean, we're talking about a mental illness, and as we've just heard, I mean, you can hear something and as a layperson think, okay, well, they must have been, I mean, what's lacking is the understanding of what that means, of what her mental health issues meant when you're looking at the evidence of what she said and what she did, right? I mean, that's lacking with a mental illness.
No one expressed an opinion on whether she possessed diminished capacity. That is true. But the experts also did testify about what the defendant said that she was experiencing. The defense expert said she was acting, but she could not give us any indication as to why she was acting. She knew that she did the actions. She just said, I just did them. I don't know. I can't tell you why, and I can't tell you what I was thinking. But and that was disputed by the people's expert. But even through that, she described shooting Ms. Johnson and then going to the next room, just like it's described by all the witnesses. And she didn't just indiscriminately shoot. This wasn't like a mass shooting where she just shot. She aimed it at Lyric Work and shot her in the head. And then she said, I'm not here for you, and even, I think, let the person out the door. She even encountered people after that and didn't shoot them. I mean, even though she believed that there were poison gas in her apartment, that she had paranoid delusions about people maybe being after her, even if she thought Lyric Work, there was some evidence that she examined Lyric Work on the computer, even if she thought she was one of the people out together, when she approached her and shot her, that wasn't self-defense. That she went up to her and killed her. I think that we do have evidence of the intent in this case, and that's why I ask, regardless of what you might do with Carpenter, that this conviction should be affirmed, because it wouldn't have affected the outcome, even if the argument was made that she had a diminished capacity. The evidence was in. So I would ask the court to deny the application, as this is not the right case to address diminished capacity. In any event, the court should affirm the defendant's convictions. If the court does overrule Carpenter or abrogates its holding, The court should make this ruling prospective only, because otherwise, there's 21 years of cases where, even in cases where they didn't really apply, we're going to get motions from defendants saying, I would have raised, or my attorney should have raised this issue. And in fact, this is, if a ruling is made based on what the defendants are arguing, that it's based on policy decisions and that science has changed and that our capacity and understanding of mental illness has changed and we treat them differently, that's perspective, if the court's going to make that decision. But I would say that I think it's for the legislature, and all of this information could be presented to the legislature. And there's been a change in Lansing, and this is a new, more receptive legislature to these kind of arguments, and they should get the opportunity to make this kind of a change in the statute. Finally, if recognized, diminished capacity should be an affirmative defense. The defendant should have the burden of proof by a preponderance of the evidence. And I say this because this is a matter of fairness. The legislative scheme, and to address one of their arguments, the legislative scheme was not arbitrary, particularly not in 1975, but also not in 2001 when Carpenter was decided. As Carpenter noted, that it is a moral choice made by the community to the way that mental illness is treated in the criminal realm, and these choices should be made by the democratically elected legislature. But absent the notice and procedural requirements that are in the statute, the search for truth would be thwarted. And I say that because there would be no opportunity to examine the defendant, there would be no notice that this issue was at play, there would be no special jury instructions to the jury, no provision for providing mental health treatment for the acquitted defendant. The defendant could seek out an expert to say what they, until they found one that maybe agreed with their position, regardless of how many they might find that didn't. And instead of an objective controlled evaluation by the forensic center and by an independent, if one or both of the parties asked for it, this would reduce the issue to more gamesmanship than it would to the independent evaluation that's available now. So for those reasons, I would submit that the People versus Carpenter was correctly decided, and that if there's going to be a change by the legislature or in the statutory scheme, it should be made by the legislature based on the policy arguments made by the defense. Unless there are any other questions. Thank you.
Just a few points. If I'm
Counsel,
understanding,
before you begin, I have a question based on opposing counsel's assertion and your earlier arguments. With respect to the correctness of Carpenter, and its abrogation holding, you argue that there's no express language in the statute. I don't think there's any dispute that the statute doesn't expressly have language expressly abrogating the common law. The question is whether the comprehensiveness of the statutory scheme, as opposing counsel mentioned, means that the legislature intended to occupy the field, which is another type of abrogation that this court has recognized, and in fact that the Carpenter case speaks to. And in particular, the provision MCL 768.36 for finding that a person is guilty but mentally ill. Why does that not indicate to us that the legislature has directly addressed the circumstance in which an individual has diminished capacity short of insanity in a way that would exclude us from...
no.
Know what?
I apologize.
You don't like my question?
No, I'm just so eager to answer it.
Well,
It's a
I'm
good
glad
question.
you are. I wish you were eager to argue it as part of your principal arguments, because it seems to me the heart of the issue, whether the case is overturned, we should address the reasoning in the case. So go ahead.
No, it's a great question, but the insanity defense is an affirmative defense, and as we already pointed out, it excuses what the defendant did. The defendant did it, but we're going to excuse it. The guilty but mentally ill verdict really can only be understood as something that orbits around the insanity defense. It's something the legislature created because they knew there would be certain defendants who clearly are going to appear in front of their juries and are clearly going to be
They
mentally ill.
they don't meet the standard of insanity,
Right. No,
right?
actually, I think it was enacted because they were concerned that some defendants were going to possibly meet, according to a jury, meet the definition of insanity, and here's a backstop. You don't need to acquit them. That's such a dramatic verdict. Just find them guilty but mentally ill. I don't think the guilty but mentally ill verdict can be separated from the insanity. The other thing
You
is,
don't have to meet the test for insanity in order to qualify for guilty but
that's what I'm
mentally ill,
saying.
do
That's
you?
what I'm saying. That's what I'm saying. It's an option for juries who maybe are persuaded that they have a defendant who's very mentally ill and
And you're
might
trying
find
to
that.
provide another option for juries for people who are in the same category. True or false?
I missed the question.
You're trying to provide another
Yes,
option for juries for
because-
people who are in the same category.
No.
So the legislature provided us one option, people who don't meet the test of insanity but still have mental illness, and you're trying to add another option.
Well, yes, because with the
it no or
guilty,
yes?
because with the guilty but mentally ill verdict, that defendant is guilty. That defendant, the jury found, they have the mens rea, they have the actus rea, they're guilty of every element of the offense.
Yeah,
But they're mentally ill.
They've decided not to excuse them from culpability in the way that they did if somebody can prove by a preponderance that they're legally insane, right? That's the whole point. The legislature's already occupied this field and made a judgment about how people who fit into this particular category, how the criminal law is going to treat them, and now you're asking us to do something different or come up with another available option.
No, I'm saying I don't believe the legislature entirely occupied the field. The diminished capacity defense is very different from the insanity defense and from the guilty but mentally ill verdict. Guilty but mentally ill, they are guilty of every element of the crime. Diminished capacity only works if a jury concludes, trier of fact concludes, that they didn't have the mens rea. So, all right, the legislature created those two options, but it's really only one. It's an insanity statute. It's an insanity statute. The guilty but mentally ill verdict can only be understood in reference to the insanity statute as a backstop to encourage juries to not acquit on the basis of legal insanity, just find them guilty but mentally ill. It's an insanity statute. We call it guilty but mentally ill and insanity statutes. It's really an insanity statute with a
Well, I mean,
backstop of
You
guilty
can
but
say
mentally ill.
that and try to gloss over the distinction, but the distinction is it applies to people who don't meet the definition of legal insanity, correct?
Right. But
So
there
it's
are,
those people
there are
who are
other
in the
defenses.
same category that your client is in. The legislature has made a determination of how those people should be treated in the criminal justice system.
Well, I believe that this court has repeatedly, and courts throughout the country have repeatedly held, most recently in People v. Moreno, which is a case I encourage the court to go back and look at because I think Carpenter shouldn't have been decided. Look at People v. Moreno, that the reasoning in that case is what should have occurred to Carpenter. This court has repeatedly stated, we're not going to read statutes as abrogating the common law unless that is stated with clarity. That's a holding this court's repeatedly made.
I've written in some cases about these differing standards that we've used for abrogation. Moreno states one of them, as I noted in one of the opinions I wrote on the topic. But we have in other cases said that the comprehensiveness of a statutory scheme creates something like a field preemption type analysis. And we've done that in other cases, and that's clearly what happened in Carpenter. Are you saying that type of abrogation, we should abolish that in Michigan and no longer recognize it?
No, I'm stating what the dissent in Carpenter stated back then, which is that, what I'm stating is they did not occupy the field. There's all kinds of issues regarding mental illness and criminal culpability.
I'm not telling you what to say, by the way. You could take that position, but we have recognized different types of abrogation, and we're talking about a particular type here. It just seems odd to me to say that this doesn't meet the test for the other type that's not at issue here, so therefore reverse the decision. Clearly, this is not an express abrogation case. We have a case a little later on our docket today where the legislature expressly abrogated all other common law remedies. That didn't happen in this statute. The only question is whether it occupied the field, whether the legislature made a judgment for us and for all Michiganders of how people who are in your client's category of mental illness, how they should fare in the criminal justice system, and whether that abrogates any other common law rules.
It doesn't. I don't believe they did I don't believe it's the comprehensive statute that it was portrayed as being in Carpenter, because there's so many other issues that apply to the criminal law and culpability and mental states. And all it really is an insanity statute with a guilty but mentally ill backstop to encourage juries to not find people legally insane. That's the nature, we all know, that's the nature of a guilty but mentally.
If we adopt what you're asking, and I think what Justice Viviano is asking you, who's going to be left in this guilty but mentally ill category? Or is everybody going to shift over to diminished capacity?
No, because, again, guilty but mentally ill means the diminished capacity defense wasn't available, didn't work. It means they had the mens rea. You're guilty but mentally ill only applies to people who have the criminal mens rea. Diminished capacity would only apply to somebody who doesn't have the mens rea because of a mental abnormality. It's not going to apply to that many people. Juries have not looked upon the insanity defense favorably. I don't think very many, I reason from that, they're probably not going to quit that many people for diminished capacity either, because similar issues, different defense. We've talked about that, I've talked about that to death, but same idea. You got the same concern.
How often do you think a defendant would raise the diminished capacity defense? Do you think it would be rare?
Well, I'm not going to say that. I mean, if there's not a better defense, they're going to raise the diminished capacity defense. Would it succeed? I don't think it's going to succeed frequently. No, because, you know why? Because the insanity...
It will become very commonly litigated, right? The experts will come in and talk about the defendant's mental illness. In almost every case, this will become sort of a dominant theme.
But isn't that what we trust juries to decide?
This is what we trust juries to decide. And the other thing is, it reminded me of something. I got to say, the prosecution's concern about
You didn't answer my question. Is you acknowledging that it will become a dominant issue in cases?
No, because there has to be objective evidence to support it. By the way, Ms. Tyson was reviewed at the Forensic Center. The people who reviewed her there, both of them, found she was legally insane. So when opposing counsel says, well, the defense, I kind of hear from Your Honor, the defense is going to go out and shop for experts. The defense in this case didn't shop for the expert. The prosecution shopped for the expert. They got one. And no, it's not going to be a problem. It's not going to be that common, because you have to have someone who has the credentials, is credible, and can come in and make a very difficult defense that somebody didn't have.
I mean, a lot of people who commit crimes in Michigan and around the country and probably around the world have a mental illness. Is that a radical observation, or?
No, not at all. But diminished capacity is not a mental, is not.
So it's going to be very clear to everyone when diminished capacity applies and when people have mental illness that doesn't fit diminished capacity? Because isn't that the whole problem with the defense, is there's no clear lines and jurors will struggle? That's what all the courts who have looked at this have said, that jurors will struggle with the many gradations of mental illness and the difficulty of determining when it rises to the level of negating specific intent. But you're saying that would be easy to do and jurors would have an easy time with that?
Well, I'm not saying it'd be easy, but it's allowed in more than half the states, it's just as Kennedy points out.
And before Carpenter.
Before Carpenter, and thank you. That I think is an important point. Before Carpenter, it was allowed in Michigan. We have the case law. It exists. It was recognized by the Court of Appeals in 1974 in People v. Lynch, but no doubt these cases were being tried as long as Michigan has had trial courts. And, it's only in 2001 when this court overturned or abolished the defense that went away. We've already had that experiment up until 2001, and I haven't seen any argument or evidence or claim that courts couldn't handle these cases back then. And people have only gotten better about these issues now. I think maybe they've become a little more cynical towards mental illness because we know more about it and we see so many people have it. So I don't think the defense is going to become, some juries aren't going to be able to understand it. Juries know people have mental illnesses. I think the public does. I think they'll be able to analyze these issues fairly easily. I don't know. I don't see it as the problem that the Carpenter majority did. I don't see it as allowing the guilty to walk the way the Carpenter majority portrayed it, although to the extent that's a problem, the legislature could address it and say if you're found not guilty under a diminished capacity defense, you have to go be evaluated. the legislature could speak, they should speak. If they wanted to eliminate the diminished capacity defense, they should have. And by the way, these concerns opposing counsel raised about notice requirements and all these things, that was resolved by the Court of Appeals in Mangia-Pound. We're not arguing any of that. We're not arguing that the prosecution wouldn't get notice of, or shouldn't get notice of a diminished capacity defense or these things.
Thank you. We've used way more than your time. So we
No,
appreciate it, and the
thank you.
case will be submitted.